Your wills and trusts. I know that sounds a little odd, but I've been teaching in the area now for about 15 years, and I really enjoy this subject, and particularly to be able to condense it into this format is a challenge, but also I hope it'll be a lot of fun for everyone here tonight. I have good vibes about this room. My friend got married recently and had a reception. It was a small reception in this room. So far, the marriage is still holding up, so I have, good feeling about the way things will go tonight. In addition to my home school at Whittier, I've also taught wills and trusts at UCLA and at Loyola, and recently I was invited to teach at the University of Houston in Texas. And that was a bit of a challenge because I knew that I'd have to learn the Texas probate code, which turned out not to be too challenging after all. And I only say this by way of introducing myself to those of you who have not studied in California. I'm sure there are those in the class who did not go to a California law school. You might be concerned about the California bar testing on this subject. And I can tell you, just having gone through that experience, that for the most part, our jurisdiction is a majority jurisdiction, and what you learned is likely going to be what we study tonight. But where we do differ, I'll certainly point that out so that you can incorporate the specific California terms. I have my email address up there, jdar@law.whittier.edu, so feel free to send me some questions along the way. And I'll also take questions during the breaks and after. I'll stay as late as you want to stay tonight. The format that I've been instructed to follow is probably one very familiar to you, as follows. We'll spend the first part of our time together just reviewing the substantive materials on wills. Then we'll review the question that you had. I believe it's question 17. In which we'll go over the suggested answer. We'll jump into the trust materials, which tends to be a little shorter. You saw from the outline it's actually about 50% the length. And then likewise jump into the trust question. And over the years, I have read every bar exam question for probably the last 20 bar exams, or even more at this point. So I'm somewhat familiar with the frequency of testing of certain topics and the way in which the examiners like you to respond. So I really feel it's my job to provide that information at the forefront. So as we go through the outline, I'll tell you how it appeared on the bar in the past, and I know the outline tells you frequency of testing, but I'll certainly reinforce that as we proceed. Well, the way I like to start to think about the wills portion, so now we're going to focus on wills, is to break it down into the smallest number of topics that we need to cover tonight. And I know the first page of your outline does that. And let me just, in my own language, suggest to you there are 6 essential core elements to answering a wills question that we'll go over tonight. The first is the issue of formation. Next, components. Interpretation. And I'll show you where these follow in the outline that you have. Distribution. Intestate succession, which of course isn't really a wills issue, but it is a distribution issue. And then finally, the topic of will substitutes. If you just look on the first page, these roughly match the writing approach topics that you see on page 1. We'll first look at any instruments that are described in the question, and we'll talk about the validity of those instruments. Then we'll move on to talk about any components, that is, things that can be integrated into the estate plan that are outside of the scope of the instruments. So first you look at the instrument, a will or a trust, for example, and then you look outside for papers or other items that could affect the distribution. Then this third area of will interpretation, it really generally refers to acts or things that happen outside of the estate, again, that affect the distribution. Finally, what's called distribution problems, and these sometimes can relate to family situations, where situations in families change, births, death of other individuals, marriage. Intestate succession, which is an estate plan by default. It's the distribution of an estate where a will is lacking or where a will only partially distributes an estate. And then finally, very briefly, we'll talk about will substitutes, which are generally contracts that convey title to property at death without going through probate. This is probably something you studied in your property class or will, but certainly we'll talk a little bit about will substitutes here tonight. Okay, just going along to my first topic here, formation. If you have a question and you're given any kind of an instrument that sounds like a will, and usually the bar is very straightforward about it. They'll say, T executed a valid will on December 1st, 1982. So they don't make you really struggle to see the will itself, although we'll talk later on about how there are hidden instruments that might be a will. But for the most part, at the outset of a will's question, typically it's very straightforward. This is a will. And now what's happening increasingly is the examiners are actually cutting out almost entirely this first part of the roadmap, because they'll often tell you it's a valid will, or T validly executed a will on so-and-so. So you don't have to go through some of the entry-level parts of the exam. So if you see that, don't even go into the discussion about the signature and over the age of 18 and of sound mind. And some of the other things we'll mention, because it's hinting to you, you don't need to talk about that. You can move on to the next essential topic. But if they don't say that, if it doesn't say executed a valid will, or instead it says wrote down on a piece of paper or type the following, then you do have to go through the validity, the will validity language. And that's what you see appearing on page 2. And there's just, again, it's a memorization issue where you really do need to just look at the elements and describe the elements. And here you see them here. And the outline breaks it down into two elements, testamentary intent and these statutory formalities. And the testamentary intent is something that's important to talk about. And what you're going to look at is, does the instrument reflect a desire to write a will? And the typical way this comes up, where it wouldn't be testamentary intent, is if somebody writes a letter to another person and says something like, I'm thinking about writing a will, or I'd like to make a will, or here is the outline of my will, something like that. Sometimes I refer to it in class as testamentary musings. That's when you know you have a problem with testamentary intent. So it has to be a present intent to make a will in the present, and anything that's separate from that, you'd want to call attention to the problem nature of the intent. And then you'd move on to this, the issue of formalities. Now, the formalities, I think, include the capacity issue, which you see referenced above. So the first of the formalities is that testator is of sound mind. You want the testator to be of sound mind. And these issues, which are talked about a little bit later on, are not hard to spot. If it tells you that the testator was in a mental institution, that's a hint that there could be some sound mind issues. The one that comes up more recently is the conservatorship. That testator is under a conservatorship. But the California Probate Code says that testators who are under a conservatorship can still make a valid will. There may be some extra requirements, but that shouldn't throw you off to immediately say lack of sound mind. But that's something that has come up a little bit more recently. So you talk about sound mind. The person has to be over the age of 18. The will has to be in writing. And there are no oral wills allowed. So now focusing a little bit more closely on the outline on page 3, I want to talk a little bit about the signature of the testator, which is part A. So the will has to be signed by the testator or by her, in her name, by someone in her presence, and by her direction. In other words, if testator doesn't sign on his or her own, then it's acceptable for the testator to direct somebody else to sign. Where you'll see this tested is the testator will call up the lawyer and say, I'm happy with the terms of the will, can you just go ahead and sign it for me? And that's an immediate flag. There's a problem with signature. Yes, I wasn't going to stop for questions. Yes, but you'll never see that on the exam, because that's actually a subject of family law. But yes, in fact, you can have someone under the 18 do it, but I've never seen that come up, but it certainly could. Just going back to the signature again, look for the direction of the testator in the testator's presence. It does not include telephonic presence. So you can't call up the lawyer and say, sign it for me. The signature can be an X, or really anything that the testator routinely intends to be their signature. So that's what constitutes the signature. Okay, this next part, the two attesting witnesses, is where I have seen some questions come up, although not lately, so it may be right for this kind of questioning. California's in the minority in that we require that the two witnesses, and this is B1A on page 3, being present at the same time witness either the signing of the will or the testator's acknowledgement of the signature. So California is in the minority of jurisdictions which require that the witnesses have to be present at the same time when they witness, when they see the testator sign or acknowledge the will. It does not mean that the witnesses have to be in each other's presence when they sign, but rather they have to be jointly present to watch the testator sign. And the reason, it's kind of an old rule, but the reason is that the witnesses should be available to testify together about the state of mind of the testator at the time the will was executed. That's why California hangs on to that. So look for the witnesses being out of the room when the testator signs. That would make it an invalid will. If it doesn't meet the statutory elements, it would be considered an invalid will. Later on in the outline, it talks about presence, and California has essentially by common law adopted the conscious presence test. Look for a blind testator. If the testator is blind, then you'd have to question, well, can the testator actually see the witnesses and understand that the witnesses are present at the same time? But if the testator is blind, for example, then he or she probably has other ways of perceiving that the witnesses are present, and you'd want to talk about the conscious presence test in that situation. All right, and those are the elements. They're very basic. It's mostly focusing on the age of the testator, the sound mind of the testator, the writing, and finally the signature of both the testator and the two witnesses present at the same time. Now, part two under attesting witnesses, interested witnesses, is tested a lot, actually. And an interested witness is somebody who signs as a witness but who receives a beneficial interest in the will, who's named in the will to take money or property. So beware, if a witness signs and they're named as the executor but they don't get any money, if a witness signs and they're named as a trustee but they don't get any money, they're not an interested witness. They're a mere fiduciary, and as a fiduciary they don't get a beneficial interest but rather an administrative interest, which does not rise to the level of an interested witness. If I were taking the exam today and I saw such a person, I would mention that the interested witness statute does not apply to Beth because she's merely named as a trustee, which is a fiduciary rather than a beneficiary. But that shows the examiners that you really understand the interested witness rule. Okay, three important things to know about the interested witness rule. Number one, if a witness is interested, it does not per se invalidate the will. It used to, that was the common law. In no state is that true anymore, but you'd say that the fact that Beth, who gets $10,000, signs as a witness does not invalidate the will. Okay? Then you'd move on. You'd say, but in California, and you see this in your outline, there is a presumption in the probate code that an interested witness procured the gift by fraud, menace, or undue influence. So you'd want to point out, but we're going to presume by an evidentiary presumption standard that witness did procure the gift by fraud, menace, or undue influence, and so the witness has to then rebut that presumption. So that's the second part, is about this rebuttable presumption that arises. The third part of the interested witness law is what's called the extra benefit test. I know it's not on your outline, but I'm just going to add it because it might help you remember it a little bit more. Well, sorry, no, I should follow more carefully with the outline. It's described for you at the very top carryover paragraph on page 4. And this is what is known as the extra benefit test. And what that says is that if the interested witness is unable to rebut the presumption of fraud, undue influence, or menace, then that person would lose whatever extra benefit they're getting through the will. So for example, let's say that testator has a will and leaves $10,000 to my son Daniel. So $10,000 to Daniel. Daniel is a witness. Well, you'd think, gee, a son really shouldn't unduly influence a parent, but in the bar exam world, that happens all the time. So if Daniel is unable to rebut the presumption, let's say Daniel lives with the testator, Daniel encouraged the testator to leave out his brothers and sisters, that would be an example of undue influence. Then you could say that Daniel has been, or would likely be unable to rebut the presumption, so that Daniel would be purged of any extra benefit that Daniel would receive under the will. What does that mean? Well, we look to the intestate plan. And if Daniel were going to receive something intestate, let's say $5,000. Let's say the estate was valued at $15,000, there were 3 children, they would have shared equally, for example. So Daniel would have gotten 5. Well, the will gives Daniel 10. And if Daniel can't rebut that presumption of undue influence, then what our probate code does is it purges Daniel of this extra benefit and gives Daniel what Daniel would receive under intestate succession. So purges him of that $5,000, leaving him with a $5,000 bequest. So those are the elements of interested witness that you'd want to go through when you see that coming up on the exam. All right, the next section deals with these capacity issues, things that can invalidate a will for lack of testamentary or mental capacity. And we'll talk about fraud and undue influence. In a minute, for a moment, we'll talk about insane delusion. But fraud, undue influence, and insane delusion are the 3 common capacity issues that you'll see on the bar. And frankly, I don't think they're that hard to spot. They don't really want you to have to wrestle so much with it. It's fairly explicit when you see these situations come up. So fraud. Fraud involves an intentional misrepresentation to the testator. So that's why it's not hard to miss, because it'll tell you Betty lied to the testator and she told him that his son had died, something like that. Something that's intentionally misrepresenting facts to the testator. But there are 2 types of fraud that you're going to highlight. You'll see them here in your outline. Fraud in the execution, fraud in the inducement. And those are the 2 main areas where you'll see that. And again, fairly easy to spot. Fraud in the execution is literally where a beneficiary will switch out a paper on the testator and will give the testator a will to sign that the testator didn't intend, or will give the testator a piece of paper, a blank piece of paper or some other document, and tell the testator you're signing the will so that the testator dies intestate, for example. So fraud in the execution is switching up the paper somehow. Execution, that is by the testator. Fraud in the inducement, a little bit harder to see, but the point is that you'll see some active misrepresentation where someone will tell a lie to the testator to get them to either change their will or write a will in favor of the beneficiary or to die intestate, anything like that. So any kind of lie that convinces and coaxes the testator to make a false will that doesn't represent the testator's true intent would be known as fraud in the inducement. The one thing to point out, I'd highlight here when you highlight fraud in the inducement, is that last part of the paragraph there that tells you that the remedy for fraud in the inducement is constructive trust that's imposed on the interest to be taken by the wrongdoer. And we're going to talk throughout the night about constructive trust, and I'll just say it out right now so when we get to it you'll know. But a constructive trust isn't really a trust at all, but it's a judicial remedy that's used to remedy unjust enrichment. So if someone's being unjustly enriched by some fraudulent action, then constructive trust forces a transfer of property. In fraud and the inducement, the remedies are possibly invalidating the will because you'd argue it doesn't represent the true intent of the testator, or sometimes cases happen where the will is already probated, and the examiners will tell you that, in which case then you'd look for some other remedy, which is you'd want to transfer property from the wrongdoer to those who were really rightfully entitled to the property. So constructive trust is the remedy for undue influence, for fraud rather. Okay, the second capacity issue, undue influence. Again, usually not hard to spot, although they can be a little tricky about that. So undue influence occurs, and you see the elements of it. I won't repeat the elements, but you see the elements laid out for you on page 5, where normally what would happen is you'd see someone who is a stranger to the relationship who gets a good chunk of the estate. And I'll tell you the examples they've used in the past. They have the astrologer. That was the Nancy Reagan will. They have the financial planner. And those are examples from the past. Now what you might see now, and they haven't done this yet, but I think it's so right for this kind of a question, is the lawyer. The lawyer who drafts the will and gets a bequest under the will. Because you can see the first element of the undue influence claim is this, if you look at page 5, 1A, confidential relationship with the testator. And so that is a very special relationship that usually involves a non-familial relationship, although courts have interpreted familial relationships to also be considered confidential. So look for the attorney-client. Look for the financial advisor and the client. Look for the priest and the parishioner, the rabbi and the congregation member. Things like that that set up these personal relationships. If that person is getting a gift, then you're going to be thinking about undue influence. And you're going to want to talk about the elements, the confidential relationship, this actively participating in the preparation of the instrument, and then finally doing it for their benefit. So you kind of want to look in a criminal law sense for motive and opportunity, and those are the things you'd look for in an undue influence scenario. And then finally you see this remedy, constructive trust. Again, you want to tell the examiners the remedy would be imposing a constructive trust on the property that is forcing a title transfer to the rightful takers of the property. Mistake in the execution would generally come up as follows. A husband and wife are given what are known as reciprocal wills, something we'll talk about later on tonight. Wills that have similar provisions and leave a common residuary beneficiary. And what happens is they sign each other's wills by mistake. Many of you might have studied those cases in law school because there's a couple of them in most of the case books. For the most part, California is unforgiving when we have a mistake in the execution. So if somebody signs the wrong will, then it's very hard to argue that that will should be probated because the signature does not represent the intent, the distribution intent of the testator. But you could argue, for example, there's a reforming doctrine, it's not in the materials, but I think the examiners would be open to this, to the discussion of the reforming doctrine known as substantial compliance. And substantial compliance isn't just a wills doctrine, you might have studied it in other areas, but the argument is that the will substantially complies with the Wills Act. The Wills Act is what we talked about earlier, the formation requirements. And therefore, someone who is disappointed because the wills were mistakenly executed could argue to the court for substantial compliance, arguing for the will to be considered valid. But mostly mistake in the execution will yield an invalid will. And then finally, you see this mental impairment of insane delusion. And typically, insane delusion is a situation where a testator has a false sense of reality, such that if you told them the truth, they would continue to have that false sense of reality. And so for the example is silly, admittedly. A silly example that's often used is, Fred believes that all Irishmen are redheads. And even though you parade a bunch of blonde and brunette Irishmen in front of him, he says, no, all Irishmen are redheads. That's an example of an insane delusion. Maybe it's wishful thinking, I don't know. But that the idea is that this false sense of reality, even if you told the person the truth, they wouldn't change their opinion. So look out for things that are insane delusion. Again, insane delusion invalidates either the will or the provision in the will that's based on the insane delusion. And you would want to talk about that as an invalid part of the will. Okay, so that's our formation issues, but only with respect to one type of will, an attested will. Attested, of course, meaning signed by the testator and witnessed by two witnesses present at the same time. But the other kind of valid will in California is a holographic will. And a holographic will is a will that is in the handwriting of the testator, signed by the testator, but unwitnessed. And it's not necessarily that it has to look like a will, but if there are papers that are handwritten, if you see anything that's handwritten by the testator in the exam, you instantly have to think about holographs, because that's the only reason that you see handwritten documents in the question, is they're trying to get you to talk about holographs. So let's talk about some of the rules surrounding holographs. California is a pretty liberal state when it comes to holographs. They would allow one of those going to the stationery, buying a form, and signing the form, and maybe putting some designations of percentages next to individuals such as son, daughter, husband, and wife. In other words, that might be a valid holograph in California. It's not in most other states. And what it means is that testamentary intent, which we talked about as an essential element of a will, could be gleaned from the surrounding printed material in a form will. We actually have a very specific probate code section about that. So that if you see someone going to the store, buying a form, signing it, and only filling out half of it, that might be considered a valid holograph, even though the material provisions aren't necessarily in the handwriting of the testator. So let's look at just the elements of the holograph. They're similar in some ways to the attested will, of course, minus the witnesses themselves. The testator has to have testamentary intent. It can't just be writing out numbers or writing out I wish or I think. It has to show you the intent, just like you would in a will. And there has to be testamentary capacity, just like there is in a regular will. But the main requirement is that, and this is looking over on page 7, C, under C, statutory requirements. Number 1, the material provisions have to be in the testator's handwriting. So the distribution, the beneficiaries, for example, and the testamentary intent, those all have to be in the testator's handwriting. So you could talk about that when you see a holograph, and we will later on tonight. Holographs in California don't need to be dated, but if they're not dated, then there could be presumptions, which you'll see in Section 2, about when the holograph was actually executed. And also, an undated holograph could call into question whether the testator had capacity when executing it, because if the testator ever lacked capacity, there might be a presumption that the holograph was done during that time. So you'd have to overcome that presumption. All right, that's all we say about holographs, because we'll talk about those a little bit later on. Conflict of law, I've seen that come up not too infrequently, and all that means is that it's a very short discussion, but you want to make it. I call that section foreign wills, and it's where the testator's will was executed in another state. They're not going to give you a situation where you have a California will and the person dies domiciled in Nevada, because this is California law, and Nevada law would apply. So you're not going to see that. More likely what you'd see is person went on vacation, they were worried about the boat sinking, the plane crashing, they signed the will in France, they signed the will in Miami, and you see there the rules. California, again, very liberal, very accepting. Pretty much, if it was valid in the domicile of the person when it was executed, or in the location where it was executed, or under California law, then it would be considered valid, but you'd want to at least flag the conflict or foreign wills problem there. Okay, going over to page 8. We're moving on then to our next section on components, things that could be used to interpret or add to a will. Integration, I'm not going to really cover. All that means is that papers that are intended to be part of the will and appear to be part of the same will be considered part of the will. Documents are considered to be integrated if they appear to be intended to be integrated. The next section, though, I will spend a minute on, because this comes up a lot. It's this incorporation by reference. It's one of these doctrines that's common law in most states, but it's actually statutory in California, which is why I think it comes up a lot. I'm going to deviate a little bit from the outline, just to, I hope, short-circuit it for you guys a little bit. There are 3 elements of incorporation by reference that you're going to want to know. I'll tell you them shorthand, and then I'll explain them. Intent, existence, and description. Those are the 3 elements of incorporation by reference. Intent, existence, description. All right, and you have a very nice discussion of those elements thereafter. Element number 1, that T must intend to incorporate by reference some other paper. So it means that it's a writing that's not a will, but that's going to be read along with the will to give meaning to the distributive provisions. But T must intend that the document be incorporated by reference. Number 2, the document has to be in existence at the time that the will is executed. So that it can't be something that's written later, except, and I'm sorry to add a little bit, but this is important, except if the will is republished by codicil. So the existence requirement can sometimes be met by a companion doctrine known as republication by codicil. What that means is you have a will, and the typical example is the will says, I desire my friend Dorothy to get some property described in a letter that I have written that's in my safe deposit box. It turns out testator didn't write the letter. The letter exists, but it's dated 6 months after the will was executed. So you'd say initially at first pass, fails the incorporation by reference test because it wasn't in existence when the will was executed. But then you see the testator 2 years later, 2 years after the initial will, but after the letter was written, did a codicil. A codicil is a supplement to a will that adds to, that is read along with the will. And when a codicil is written, then the will is republished or re-executed as of the date of the codicil. Well, that means that through republication by codicil, this letter, which initially was 6 months after the original reference, was now in existence at the time the will is executed. So that they like to play with that a lot, so watch out for that. So that's what the in existence is. And then finally, description. Our probate code says that the writing has to be sufficiently described in the will so as to permit its identification. And you see that in the outline. So the will has to sufficiently describe the document to permit its identification. So that's incorporation by reference. Acts of independent significance is another important doctrine that really, again, it sort of sneaks up on you. It's not one of those obvious. But basically, the acts of independent significance doctrine says that a will's provisions with respect to named beneficiaries or named property can be changed by things that happen after the will is executed that are unrelated to the will, that have independent significance. And I'll give you two just quick examples. Let's say that you have a will that says, I leave property to my cousins, for example. And it doesn't specifically describe, it has a class gift to cousins. And then after the will is executed, there are more cousins born into the family. Well, the original group class could say, hey, we're not sharing with these other folks. They weren't in existence at the time. The will refers to a class, let's say, at the time the will is drafted. Well, the cousins would say, well, our birth, our coming into being was independent of the will. We weren't born just so we could take under the will. It's just adding or changing the beneficiaries by independent actions could help to distribute the property differently than was contemplated by the will itself. The more typical example is with property, and we're going to study that tonight. If you saw the question tonight, there was a reference to a specific asset, a house, and the house changed. Another example I give in class is I leave my wedding ring to Betty. Well, at the time you had a little 1 carat. I'm not knocking 1 carat girls, by the way, but you had a 1 carat, and things got better, and on the 10th anniversary you got a 3 carat. So you changed the gift, you increased the gift in value substantially, so you might argue, well, you're changing the gift, you have to rewrite the will. No, but you're getting that 3 carat ring was independent, it had independent significance. You wanted the extra ring, so the gift increases through acts of independent significance. So that's what that looks at. Okay, moving on, this idea of subsequent testamentary acts. We'll talk a little bit about revocation, and then we'll move on. And a will is an ambulatory document, meaning that it can be revoked at any time up till the moment of death. It doesn't take effect until death, so it's always free to be revoked. In California, there are two ways in which the testator can revoke the will, by subsequent will or by physical act. And so you'd want to say under California law, a will can be revoked by subsequent will or by physical act. All right, let's talk about those real briefly. Subsequent will means that there's another will that's written. And following along in our outline on page 10, you can see that the subsequent will can either expressly revoke. For example, it can say, I hereby revoke Will 1, or will written in 2001. So that would be an express revocation. Or a subsequent will can also revoke a prior will by implication. And really what this means, and the way it's described in the probate code, is by inconsistency. So will number 1 says, I give all to T. And then will number 2 says, I give all to X. It doesn't say I revoke will 1, it just says I give all to X. Well, that would revoke will 1 by inconsistency because the provisions are completely different. So that's an example of a subsequent instrument revoking a prior will. The second way that wills can be revoked is by physical act. In California, again, is very specific on that. A testator can revoke the will, and they have to have 2 elements of revocation by physical act. They have to have intent to revoke, and they have to have, that's number 1, intent, and number 2, an act that touches the words of the will. So the act is a very specific act. It has to touch the words of the will. And here you see it described as, you see under 2A1A, right in the middle of the page, that revocation by physical act, physically cancel, burn, or tear. It's actually, there's even a longer list in the probate code. But Writing an X over the document is fine. Tearing it up into pieces is fine. Lighting a match to it, as long as it touches the words of the will, is fine. Writing in the margin, revoked, is not fine, because that doesn't touch the words of the will. You might have arguments about a holographic revocation, but not by physical act. It has to touch the words of the will. Does it have to be the testator? No. Just like signature, it can be at the testator's direction, but it has to be in the testator's presence. So when testator says, I want you to burn it, the testator has to be in the room to witness that that's exactly what's going on. We'll have that problem tonight. So that's revocation by physical act. On page 11, there's this discussion about interlineation. I'll just say one word about that. So this is revocation by physical act. And if you had a gift that T gives $5,000 to B, just to make this short and simple, let's say that was a provision in a California will. Well, California follows the doctrine of what's known as partial revocation by physical act. I'm sorry, I'm looking for another color. Here we go. Partial revocation by physical act. So that if the testator takes out a pen, you can see I've crossed out the 5 and would write $10,000. In California, since this touched the words of the will, this would be valid. This would be a valid revocation of the gift to B, partial revocation by physical act. But what we'd want to talk about is whether the $10,000 would be valid. This is known as an interlineation, where you write a new gift out to B. And the answer is probably not. Why? Well, look at the $10,000. You could argue it's a holographic codicil, because it changes or supplements the will and it's in the handwriting of the testator, but there's no testamentary intent, right? It's just the $10,000. There's nothing here that says, I give $10,000 to B. If there were, you could analyze it more easily as a testamentary intent, but just the $10,000 is probably not going to be a sufficient codicil. And so what might happen in California is B gets nothing, because the gift to B has been revoked. The new gift fails for lack of formalities, in this case testamentary intent. And this is where we come up with our favorite doctrine, dependent relative revocation, which I know comes up a little bit later. So let's move to that on page 12 and 13. Dependent relative revocation is something you should be thinking about if you see a revocation of a gift, either a partial revocation by physical act, or a total revocation by physical act, or a total revocation by a subsequent gift or will. If the testator appears to have been mistaken, wouldn't have wanted the revocation, then we have this reforming doctrine known as DRR, or dependent relative revocation. And what DRR does is it's a judicial remedy, so it's not a statutory remedy, it's common law, strictly common law. And it allows a court to cancel a revocation that's based on mistake of law or fact. That's what DRR is. It allows the court to cancel a revocation based on a mistake of law or fact. And another important element to add, which is in your outline here on page 13, is where you see about 3/4 of the way down the page, testator's intent. The intent is what drives DRR. The court will look to whether the T intended to have a certain distribution, and we'll figure out what T's intent was posthumously, but the intent is always important. So just to use this as an example, it looks like T intended to give B more than $5,000, but since the testator failed in giving this gift, then DRR would be used in this case for B to argue that the revocation by physical act of the $5,000 should be canceled or set aside because T's intent was to benefit B by more than the original gift. And most likely in this situation, DRR would apply and would cancel the revocation by physical act, and B would get $5,000. It's explained nicely in the hypo. It's very similar to the one I've given you, but you can take a look at that later. Just for example, if instead of crossing it out and putting 10, T had put $2,000, then B would receive nothing, because it looks like the intent was to reduce the gift. And since the $2,000 can't be valid for the reasons we said, no testamentary intent, and the partial revocation by physical act is valid, DRR would say that B can get nothing because T's intent was to reduce the gift. So the intent was not to cancel the revocation of the $5,000. In that case, B would get nothing. So DRR, look for DRR if you have a revocation that appears to be mistaken. It has to be based on some mistake about law or fact. This is a mistake based on law because the testator mistakenly believed that these interlineations would have legal effect. She was mistaken. A mistake of fact is where you might write a codicil that says, I hereby revoke my gift to John because he died. And if it turns out John didn't die, that's a mistake of fact, and the court would use DRR to cancel the revocation of John's gift. Okay. We've already gone over codicils, which you see on page 14, 13, and 14, but just say a word about them. A codicil, again, is a supplement. It's read along with the will. But I have, if you don't mind, I have this little demonstration here. But I want to show you something about revocation of codicils and wills. So let's say that the black pen represents the will, and the red pen is a codicil. So T writes a will, I give everything to Betty. But then T decides, but I want to give my car to John. So you'd read those together, and you'd give the car to John, but you'd give everything else to Betty. So they stand as one unified plan. Now, let's say that the testator changes his mind and says, no, I don't want to give the car to John after all, and revokes the codicil, tears it up. Okay, revocation by physical act. The will, giving all to the first beneficiary, I'm forgetting now, is valid and would remain valid. On the other hand, if the testator decided, well, I don't want to give all of my estate to that named beneficiary and revokes the whole will, the codicil falls away because it has no independent ability to exist. So revocation of a codicil does not revoke the will. Revocation of a will revokes all codicils that are attached to the will. So you often are going to get codicils, and if you can just kind of remember the graphic, then you'll be able to know how to handle the distribution. A codicil is a will in the sense that it has to meet the requirements of the Wills Act, either attested or holographic. It has to meet the same requirements that we talked about earlier. Okay. Moving on to page 14, the distribution problems. The Domestic Partners Act was enacted and is in full force. And Sherry and I were actually talking about this the other day. I said, gee, I really think they're going to have a domestic partners question, or at least part of it. And really for wills and trusts, I guess the key to remember is that anything that you learn about spouses is going to apply to domestic partners. They're could be considered first-line heirs. Something we didn't mention that's in the materials, I'm sorry, I know I should reference it for you, which is revocation by operation of law applies to domestic partners as well as to spouses. Forgive me for not highlighting that, and let me just mention that now. It's on page 12 under the revocation. It's not something that testator necessarily does, so I don't usually think about it in my revocation area. But if spouses divorce, then any provision in a will for a spouse is revoked by operation of law automatically. The divorce does not have to change the will. The divorcing spouses do not have to alter their wills in any way. I'd like to add an addition to your wills, and I talked to Sherry about this. On page 12, under 3, you see that the will is revoked by operation of law, and it says dissolution of marriage after execution. I would add in there dissolution of marriage or domestic partnership. If a domestic partnership is dissolved and there had been a pre-partnership will, then the domestic partners are out of the will by operation of law. And this is where I think it might come up, where they register, one of them drafts a will, and they break up. And that would revoke the provision in favor of the domestic partner, just like it would if there was a divorce. So the outline, I think, very nicely goes through the requirements of domestic partnership. And again, I think the key is to remember that essentially the same rights and liabilities in the wills context that applies to spouses likewise applies to domestic partners. Okay, moving along, I want to focus next on the interpretation. We're kind of moving to the next part, which are interpretation. How do you interpret certain wills? And that brings us to page 16, ademption by extinction. This comes up a lot, and there's just a few small rules. I know you're memorizing thousands, probably tens of thousands of rules, so this is just one more. But ademption means to take away. It means that property that's described in a will is no longer available at the testator's death. It's been sold, it's been consumed, it's been donated, it's been destroyed, but it's not available. And so if someone is named as a beneficiary of some kind of property that's not there, you talk about how the gift has been deemed, and they would not get the value of the property. The main rule to remember about redemption by extinction is it only applies to one category of gifts, and those are known as specific gifts. And specific gifts are specifically identified property. The most common example is real estate. Real estate is unique. It's described very specifically, typically by address, so that if you see a gift of specific property and it's not available at death, it's deemed. The named beneficiary gets nothing. Other keys to redemption is if a will says, I leave my, they use the word my, and for example, they would name stock shares, my 100 shares of Apple stock, which will go up on Friday when they sell the iPhones, by the way. Then that would be an example of a specific gift that if it's not available in the estate would be deemed. And so if you see that something is deemed, then you have to say that the beneficiary does not get the named property because it has been deemed by extinction. It's extinct as far as the estate is concerned. The companion doctrine to redemption by extinction is called redemption by satisfaction, and you see that on page 17. And all that means is that there's been a gift named in the will, but the testator has given the gift early to the named beneficiary, has satisfied the gift early, but as you'll see, and the rules are described there, you have to have a writing to evidence redemption by satisfaction. It has to be in writing. Either the testator or the beneficiary has to sign a writing. Okay, let's move on, and we're going to talk a little bit more about interpretation, things that help us interpret the will, usually because events occur after the will is executed. And let's go to a couple of really heavily tested areas on page 18 and 19. We're going to talk about lapse and then omitted heirs. And again, these show up quite a bit. If this is my mantra when I talk about lapse. Dead people cannot own property. So if someone is named in the will that's already dead at the time that the testator dies, they can't own property. You can't take it with you. You can't give it to them. Dead people cannot own property. So lapse is a situation where a beneficiary is named in the will and the beneficiary predeceases the testator, dies before the testator. So they're not around to enjoy the property. And so if you see an example where someone names beneficiary who has died, you say the gift lapses. However, in California, as in every state, statutory law provides what's known as an anti-lapse provision. And it's actually written out very nicely here how you would approach that, and we'll see this later on tonight too. An anti-lapse provision says that if someone predeceases, it may be that their issue, the issue of the predeceased beneficiary, would take the property instead. So I want to make a slight adjustment to your outline because there's, I think, a misstatement of the law, and since it comes up a lot, I thought it was worth your time to look at this. This is on page 18. See E in the middle, lapse and anti-lapse, heavily tested. Skip down to where the all caps say anti-lapse, state on the bar. So I just want to read you the law because, again, it's slightly different. However, California has an anti-lapse statute that provides that if the beneficiary is related to the testator, and here's where I'd put a caret and write the following. The testator or the testator's surviving, comma, former, comma, or deceased spouse. Okay, so the beneficiary is related to the testator or the testator's surviving, former, or deceased spouse. The gift passes to the issue, and then I would again put another caret, and I would say issue of the beneficiary, just to clarify, rather than lapsing. The issue of the beneficiary rather than lapsing. So that's I think a more clear description of the law. And actually, it's when you read on, you'll see that it is actually spelled out on page 19. But I wouldn't want you to have an inconsistency in the statement of the rule. So that means that when you see someone who's predeceased, you want to go through the whole anti-lapse analysis. You're going to say, well, John predeceased, but John was related by blood to the testator and therefore might be eligible for application of the anti-lapse. If John has issue, then the issue would take in place of John. There are two exceptions to the anti-lapse rules. That is when it won't apply. And again, it's in your outline. One, where there's contrary intent. So in other words, if the testator says to John, if he survives me, well, if he doesn't survive, the testator's already thought about the possibility that John could predecease. So it wouldn't apply if there was contrary intent, or the second exception is known as a substitute provision. To John, but if he doesn't survive me, then to Betty, that would be a substitute. It would not apply in that situation. The way they try to trick you, I hate to use that, but is by making the lapsed gift to the spouse of the testator. If you really read it carefully, which I know when you absorb this later on you will, anti-lapse statutes do not apply to the testator's spouse, only to kindred or relatives of, see, it's related to kindred or relatives of the spouse, not to the spouse, him or herself. And if you followed it through, the reason is that who gets at the issue? So if you have issue with your spouse, your children, and you don't want to leave them anything, then by applying anti-lapse to your spouse, you'd be really going against what the testator had already wanted. And likewise, if you count the spouse as part of the anti-lapse, you'd be giving it to potentially to your stepchildren, right? The issue of your spouse, which again isn't what most people would want if they haven't specifically written it into their will. So that's why the spouse is not eligible for application of the anti-lapse statute. So that comes up, and we'll see it tonight. Next, omitted heirs. The two kinds of omitted people that might be able to overtake the words of the will to get an intestate share are children who are born or adopted after the will is drafted, or executed rather, and these are known as pretermitted heirs. Children who are born or adopted after a will is executed. Look out for republication by codicil. You can have that situation where you've got a will executed in year 1, child born in year 2, right? Then that child would be pretermitted. But then testator executes a codicil and doesn't include child, then the child is not pretermitted because they were not born or adopted after the will was executed. So just be careful for that. So heirs are one, children are one. The second is a pretermitted spouse. And this is someone who becomes a spouse after the will is executed. So the timeline in the spouse case is you would have will, marriage, death. Hopefully there would be some things in between, but pretty much that's how it would work. So that the spouse then would be pretermitted because the will was executed before the marriage. And these pretermitted statutes are based on the assumption that the testator wouldn't mean to leave out the child, wouldn't mean to leave out the wife. And so the codes then will give the pretermitted child and the pretermitted spouse essentially their intestate share. So if you see a child who's pretermitted, they're going to be arguing for their intestate share, something we'll get to in a minute. We're running out of time, so I don't want to take up too much of your time, but I do want to point out for you to look at the exceptions to the pretermitted child and pretermitted spouse areas. There are 3 exceptions to those. Largely they involve intent. Did the testator intend to omit the child or the spouse? And also, did they provide for the child or the spouse already, somehow outside of the will, sometimes through a prenuptial agreement in the case of a spouse, or from an inter vivos gift to the child. And these are nicely laid out for you. The pretermission exceptions are on page 20 under section B at the top, very nicely done. And those are for children. For spouses, the exceptions are in the middle of page 21. And again, they're somewhat similar. It's the intention or providing for outside the will, but I really urge you to memorize those exceptions because they do come up. Finally, moving on to the intestate, we're down to intestate succession. It's true that these come up a lot, but they're usually fairly incidental. In other words, after you've decided that a will is invalid or that a part of a will is invalid, then you're usually going to have some relatives left over, and you want to decide where does it go. All right, just some rules of thumb. In California, the first thing you want to do is divide the property into community property and separate property. This is where you get your crossover questions with community property, where you have to know what was marital asset acquired during the marriage, what was community property, what was separate property. So there's different rules for intestate distribution for community property than there is for separate property. You can see them again. They're nicely laid out for you on page 22. You see that under intestate succession you have the bar hint, and then you see part A, passage if the decedent spouse survives. Again, rule of thumb, if a surviving spouse or domestic partner is part of a community property allocation, they take all of the community property. Now remember, with community property, you own 1/2 as it's earned anyway. So really you're talking about the 1/2 of the intestate share passes to the surviving spouse or domestic partner, leaving them with all of the community property. Separate property is more confusing and there's more fractional shares. Separate property distribution depends upon what the family structure looks like at the death of the decedent. If they're survived by a spouse, the spouse can get a fractional share depending on how many issue are left behind and whether the testator or the decedent had parents or siblings. And again, I'm not going to belabor these fractions, but the outline does a very, very good job of going through with you the shares. But again, I think if you can remember, all the community property goes to the surviving spouse. As to separate property, it depends on how many children survive. If there's only one child that survives, then the surviving spouse takes 1/2, the child takes 1/2. If there's 2 or more children or lines of children, then the share to the spouse gets reduced. This I'm looking on page 23 at the top. And the partner gets 1/3 and the children get 2/3. So it's either 1/2 or 2/3. And usually they just want you to know that that's about as far down the family line as I've seen them go. So with that, I was planning to give you some time in between, and I sort of like to do that. So why don't we take a 10-minute break? I'm here to answer. And the issues are usually limited to about 6, 7, 8 at the most. And just like many of the questions, there's usually 3 kind of major issues and then 3 to 5 sub-issues within each of those major issues. So if you're spotting that many, that's about the right number. And then the student asked a question at the break about how thorough to be and how many alternative arguments to give. And that's what we're here for 6 weeks, 8 weeks talking about, because I can't really answer that specifically other than to say, having sat in and watched the examiner's grade, which I have, they definitely prefer comprehensive answers, that is hitting or spotting the issues over an in-depth analysis of 1 or 2 issues. I said this to my students in the past. Taking the bar exam is like playing the old-fashioned game of pinball. I know, gosh, I don't think there's any way I could explain that other than dating myself completely. But it's one of these ideas where you want that, if you will, that sort of ball to hit as many of the issues as you can. You don't want it to get stuck where it just keeps going back and forth in one issue. You want to be as comprehensive and hit the issues, because they do sit there and they have their, you've heard this all, they have their checklist, they check off, did you get this issue, did you get that issue, and so on. And you're going to see in the answers tonight, these are the model answers that the bar has provided to us. There are a lot of mistakes. There are a lot of mistakes in these answers. So they're not looking for perfection by any stretch. They're looking for comprehension. In the wills, 6 to 8, I've never seen more, I've seen fewer, so it's really a very good range. And if you follow along this roadmap, I think you'll have a good sense of it. All right, now, my understanding is everyone has read the question and has actually prepared the question. So we don't need to spend time on that. Now, you guys don't have anything other than the question in front of you right now, correct? Okay. Do you have the answer to question 17? That at the bottom is labeled page number 88 through 96. Do you have that? Sorry, I have that with me, but so I have what I was given. Sorry to take your time for this, but I have the 1-page question, and then I have 2 answers that were provided. These are actually these answers provided by the bar examiners. Do you have that? It's labeled Trust/Wills 88. Can you raise your hand if you have access to that? Raise your hand if you don't have access to that. So, okay, it's in the answer book. Does everyone have their answer book or could share with a colleague tonight? Because I want to go over that in addition to the approach, because I think they're both important. I hope I'm not deviating too much from the normal format, but I can do both of them quickly. So if you could follow along with another colleague. All right, so we're looking at answer A to question 17, childless bachelor. All right, just look at that page. Just look at the page. And you can see the preference for the examiner to not read a lot. I mean, and I'm sure that folks have talked to you about the mentality of the bar exam graders is strictly boredom. It's the most boring thing you could imagine doing. Other than going to certain movies, but we won't discuss that tonight. So in other words, they want to get through this quickly. And if they see a page like this one that has everything nicely outlined and spelled out, they're happy and they feel like they can go through it and they can check off their list all of the issues you're supposed to spot. I know just from my own personal experience, I usually have 125 students in my wills class. If I give an exam and I open up the ExamSoft, the type page, and it's just straight text, and there's no breaks, and there's no point headings, I just run to the refrigerator. I cannot stand it. I want to see the student do the work for me. I want the student to create that roadmap, to underline for me, to highlight the issue, so that and I've got my checklist too, I can just check it off. So you want to be as reader-friendly as you can be, which means issue spotting and letting the grader know, hey, I know what these issues are, and I'm going to give it to you in a digestible format. So just looking at this page, you can see that being done. All right, so let's take a look at the answer. So this student rushes at the beginning, I think. I think the student is nervous at the beginning and really rushes. And you see later on the student calms down. You can see this in the exam, but obviously not to his or her detriment. So they don't even create an issue at the beginning. At the very beginning it says 1994 will was validly executed. Did you need to say that? No. They tell you that in the fact pattern. Do not repeat the facts, at least verbatim. There's no point in doing that. Then they go on 96 will 2 was validly executed, and so on. Okay, and then you get into 98, the revocation of will 2, which is kind of where the problem actually starts. And so let's take a look at that. So revocation of will 2. A will, and this is a strict IRAC exam, which is it's a sub-IRAC or a mini IRAC of each individual issue and sub-issue, and you see it very clearly here. So revocation of will 2, that's the issue. Was will 2 revoked? And then you see the R, the rule. A will can be revoked in whole or in part by physical act. This power to revoke a will exists until the testator's death, and exists even in the face of a will contract not to revoke. To revoke by physical act, the testator must. And then you see the elements here. So this is just a statement of the rule. It's the R in the IRAC of whether the will was revoked. Okay? I won't repeat or read the elements, which are fine. They're nicely memorized here. Okay, then you see Tom wrote, that's the A. This is applying the rule to this particular set of facts. And again, I'm sure you know this is where a lot of exams fall short, where the students really know the rules, but they just can't translate the rules into the facts. And the examiners have on their checklist this A of IRAC. They really want to see the facts come back at them, not verbatim, but integrated into the rule. And that's I feel like that's the hardest part of the exam. So let's examine how this student does it. Tom wrote that he hereby revoked my 96 will. Tom also wrote telling Lois to destroy W2, so kind of repeating the facts a little bit here. Saying he revokes his will clearly implies he intended to have the will revoked. Requesting destruction, W2, clearly implies that he does not want the will to have effect. W2 was torn by L. You know, this is what I think earlier on in your book, Sherry refers to as chatting. I love that, chatting, where I can tell students still really nervous, wants to write down the facts that are relevant to revocation by physical act, but hasn't quite settled down, and so writes these facts in. But again, no harm. Let's move on. But the PA, physical act, the tearing, was done outside the presence of Tom. Tom writes a letter to L telling her to revoke, but he was not there when L tore up. So there you're getting to the meat of it, the fact that it was done at the testator's request with intent, but not in the presence. The PA was done at Tom's direction, though. Tom wrote telling T to destroy. Again, this is repetitive. This is too much. You don't need this much here. But then finally, the C, or the conclusion, because W2 was not torn in Tom's presence, W2 was not revoked by PA. That's fine. I think the middle section is a little too long. You didn't need to repeat the facts quite so much, but the student does a nice IRAC ultimately here, literally breaking down the paragraphs into I, R, A, C, and that's what the examiners like. Now we move on to the next issue, holographic revocation. There's the issue, I. Next sentence is the rule. Will can be revoked by a holograph is basically what they're saying. And then you see it, they describe the next part as the A, the facts. In handwriting, it says the letter was in Tom's handwriting, and then signed, letter was signed by T. Those are the A, those are the facts. All right, turning over, again, the material terms, the student integrates the facts. Tom wrote, I hereby revoke my will with the intent. And then you see the analysis going on, and that's all fine. I want to turn to, because I don't want to I want to get to the approach issue as well, but I want to turn to page 90, which is the third page of the answer. And again, you'll see why this is considered the sample answer. Look at the top. This is where the student is talking about whether the first will, which is referenced in that revocation letter, can be incorporated by reference. And look at the middle of that page, and I'm looking now at the second paragraph. As I discussed in the holograph revocation section, the letter is a valid holograph. So this is how you refer back to ground you've already covered. But look at the next part, to incorporate by reference, and then they create this shorthand, I by R, we need. And the student then sets out these four elements: intent, the existence, and then they combine three, what we described as the sufficiently described, into 3 and 4, which is fine. But it's this kind of level of detail and memorization that impressed the examiners to give this to you as a sample answer. So having looked at sample answers over the years, those are usually the ones where the students have really committed to memory the intricacies of these rules. And we talked tonight about the rules that come up a lot: interested witnesses, incorporation by reference, ademption by extinction, omitted children, omitted spouses. And each of those have elements, usually only 2 to 3. But if you can memorize, and I know there's a lot of memorization, but if you could memorize even the separate elements of each of those and could recall them in the way that this sample answer does, that's where you get your points. That's where the examiners say, oh, okay, this student really knows what she's talking about. This student he's really committed it to memory. And that's why this is the sample answer that it is. Okay. Let's look at ademption. One of the issues that comes up here. When a specific device is disposed of by T during lifetime, the effect of that ademption on T's will is determined by T's intent at the time of the disposal. That's fine. This is the example where the house is named in the will, the house is sold, but another house in the same area is bought. Tom sold house number 1, H1, and bought house number 2. They were both in Oakdale, and Tom knew that his W1 said my house in Oakdale. The intent is not too clear. But absent other facts, the probate court may rule that Tom intended the beneficiary to get H2. I just want to point out, this is an example where you don't have any evidence of what the intent was. And this is a word to say, don't make it up. If you don't know and it's not clear, then it's okay to say the intent is not clear. They don't want you to make it up and to say, because it's in the same area, he intended to give the second house. No, you don't know that. Don't go, you can extrapolate to some extent, but if you don't know and it's not clear, it's okay to say the intent is unclear. All right, that's another sort of message from this. Lapse, let's look at that. There's an issue here of a predeceased beneficiary. If a devotee dies prior to T, then the devotee lapses. No, that's not right. It's not that his devotees lapsed, you see that? But rather that it's the devise, which is the gift, that lapses. So you'd have to really, if you were going to make this accurate, you'd say, if a devotee, that's the beneficiary under a will, dies prior to T, then his devise lapses. And again, this is getting toward the end of the exam. The student is tired, they make mistakes. Sample answer, it's okay. Unless an anti-lapse statute is implicated, California anti-lapse statute requires. The lapsed person was related to T or T's current or former spouse. The statute actually says is kindred of, but related to is fine. And the lapsed person left issue. But there's actually another element to that which we talked about, which is that there's no contrary intent or substitute disposition. But it's not, that level of detail is not required in this particular exam. Then the student goes on to talk about the surviving issue and so on. And then finally, the last provision on the distribution, the student sums up the answer by going through the different assets. And the examiners really like this. When the question is, how is T's estate distributed, summing it up in the end is very effective for the examiners. All right, so and the second answer is in a way actually even better, I think. Answer B, if you get a chance to go through it. And just look with me, if you will, on page what's labeled 92 at the bottom. Look how beautiful that is. You've got the point headings, you've got numbering, you know you're marching through this roadmap. You're going to the formation, which includes the revocation issues, you're going to interpretation, you're going to distribution. It's just the format is almost as important as the substance in this exam, and you can see it really, really nicely if you just look through this exam and what it provides. I want to switch now to the approach format, which is this document, and which I think is what Ann passed out now. because this is, I know, how you're studying to prepare for the exam. So I'd rather spend a little bit more time on this. And of course, the advice you're given, which is excellent advice, which is pay attention to the call of the question. And Will's questions frequently have 2, sometimes 3 separate questions. And they can be related, but often they're not. So in a Will's question in particular, I would say it's important to pay attention to the call of the question because they're very specific, as they are here. So here you see the question is really, if you're looking at the question itself, how should Tom's estate be distributed, discussed? This is rare in that there's only one. Usually they'll have 2 or more questions, and this one you just have 1. So that means you're going to have to look back to this roadmap and talk about formation issues and components and so on. And I think that's the way this is structured. So let's take a look at it. All right. So what you see here is at the top left-hand column, the very beginning of it is the basic question, which is right, to put in the call of the question. What should be used to distribute the estate? And basically what this part of the exam is having you review the validity of testamentary instruments. What are the testamentary instruments, and which of them will prevail as the valid instrument? And that's my way of describing the valid testamentary instruments. So let's just go through this, assuming that I know you've read the problem. Okay, so point number 1 is we know that both the 94 and the 96 will were validly executed. We don't have a problem with that. It says it right there. You don't have to go through any of the formation issues. But then, if you have 2 wills, you always are going to have a question of revocation. If you have any subsequent will, you're always going to be looking at revocation. So that's why point 2 says, does the 96 will revoke the 91 will? And that's where you go into your eye-racking of your rules about revocation, that a subsequent will can expressly revoke a prior will, or it can do it by inconsistency. That's the implied revocation. That's the rule. The analysis is pretty straightforward. There's a complete new will. It seems to dispose of all of the property, and therefore it would supersede or it would revoke the prior will. Just a hint, and you probably learned this in your wills class, if a subsequent instrument has a residuary clause, that is, it gives away the residue, it is a revocation by inconsistency. It's not a codicil, because you can only give away all the rest in something that completely revokes a prior will. So if you have one instrument that says this to him, that to her, and the residue to X, that's a complete will. If the second instrument says this to her, this to him, and all the rest to whomever, that's a will. That's a subsequent will that revokes the prior will by inconsistency. It's not a codicil. So that's something to look out for, is does it have a residuary clause? In this case, it does. The residue goes to the museum. All right. Then we move on because we have this third sort of thing here, this 98 letter that was written and sent out in Tom's handwriting. So the third issue then is marching through the instruments. Oh, and by the way, always start chronologically with the first instrument. When you have a series of instruments, I always find it the most helpful, start with the earliest, the oldest, the first drafted instrument, and then move on, because you can see any subsequent instruments have the effect possibly of revoking. So you need to establish the validity of the first instrument, then you move on to any subsequent instruments, and that's what's nicely done here. So point number 3 was the 96 will revoked. Okay, that's the issue. Here's the rule. Again, a will is revoked by physical act or subsequent will. We already now have that one down pat. But this one you have to break it up into sub-issues, which is done here, which is, well, was it physical act or was it revocation by subsequent will? We'll start with physical act, because that's what happened here. It was torn, so that makes sense. You see the statement of the rule, burned, torn, obliterated, or destroyed, which is, tearing and so on. But it has to be either by T or, as we know, with the intent and the purpose of revoking. We know the subsequent rule about in the testator's, out of the testator's own hands, in someone else's hands, but we know the rules in their presence. Okay, so that's a nice statement of the rule. And then the analysis is straightforward. It's what we saw in the first answer, but it melds, and that's the key. It melds the facts with the law. Here the answer tells you that T wasn't present, that T merely directed Lois in this case, and even though she complied with it and even though he intended it, the fact is that the Wills Act is very strict and it's strictly construed. And if it's outside of the testator's presence, there's no way that that's going to be considered a valid revocation, because the Wills Act is very strict about requiring the presence. So at the end of the analysis it says, she, that is Lois, third person, complied with this direction, but the revocation did not occur in his presence. Therefore, that's our conclusion, C, the 96 will was not validly revoked by physical act. So that's a nice way of going through one of the major issues in this case, which is the validity of the testamentary instruments and the revocation of those testamentary instruments by subsequent will, as in the case of 96, and by physical act, as in the case of the 98 instrument. So now we can move on. All right, so now that we've established that the 96 will was not revoked, we can move on to the next point, which is in the right-hand column, about how should the assets be distributed. Some of you, when you did your samples, might have said, well, I next need to talk about the 98 instrument as a valid will. And you know what? I think that's fine. If you look at the next answer, B, they kind of take that as a position, marching through the instruments. And that's fine. The examiners typically don't care about the order of your issues as long as you spot the issues. Because I've seen examples where excellent answers have the major issue at the end. Students just forgot or it didn't occur to them. And those get very high marks if they have the quality of a good exam. So in the order of the issues isn't really that important. Although in a wills question, because you kind of march through this question of validity to interpretation, it helps you to stay on course. But let's look at this second part. Okay. It says the estate will be distributed under the 94 will, and it tells you Tom's estate is the house and so on. Before we get to that, though, let's flip over the page. And now I'm going to be on page 2 in the left-hand column, because we're continuing our discussion about the instruments. Okay, so let's go ahead and do that. All right, so you see in the left-hand column about the 96 will. Was it revoked by subsequent instrument? That makes sense. We've said in our statement of the law, revocation two ways, physical act, subsequent instrument. We covered physical act. We decided no. Now we move on. Well, hey, this looks like a will. Maybe it's a will. It's in writing. It's signed by the testator. That should start us thinking about holographs. So that's what we're going to analyze here. Is that a subsequent instrument? And then you see the rule that it can be revoked by a subsequent will. All right, and that's nicely stated. Next, we'd ask, well, is this document then a will? Does it comply with the formalities? And then you see the rule that a codicil or a supplement can be valid as a holograph. We know it's not attested, so we can rule that out. There's no witnesses. Has to be in the testator's handwriting, signed by the testator, with the material provisions in the handwriting of the testator here, the testamentary intent. So that's the rule. And this is where your analysis can really shine, because you can bring in the language of that subsequent instrument and meld it with the rules that we've just stated. And let's just take a look at that. Tom handwrote the letter in 98, and he said he wanted to revoke. And going to the bottom there at the end, Tom's use of the word will as a noun demonstrates testamentary intent. Because you see the word will, you understand the person is thinking about that, and that does give you the testamentary intent. Conclusion that it is a valid codicil. All right, and then moving on, does the codicil then revoke it? And this is my rule about if it has intent to revoke or it has a complete disposition, then it will revoke it by inconsistency. And here you see the analysis here says that by saying you're revoking the will, then you certainly would use that to show intent to revoke. And that's how you get to that part. All right, finally, just to finish up this, this section, on page 3, which is still the part about the instruments, you have this issue of revival, something we didn't talk about tonight, but I'll just quickly mention. The California Code is a minority jurisdiction in the sense that we do permit revival of revoked wills. And revival is a companion doctrine to the doctrine of dependent relative revocation, where DRR could actually cancel the revocation of an instrument. Revival can do more. It can bring back an instrument that has been validly revoked. And the rules provide that revival of a revoked will is possible typically, and this is in your outline, where there is evidence of intent to revive. And it has to be clear and convincing evidence of an intent to revive. And without reading through it too much, the exam does a really nice job of setting out that rule about revival, of applying the facts to the revival scenario, and then determining that this 94 will, in fact, can be given meaning under the probate code, and that's done very nicely. Let's take a look, just so we could finish up this question on page 1, to the distribution of the estate under the 94 will. There's at least one other doctrine that could have been used here, which is used in the sample answers, and that's that incorporation by reference doctrine. So you can get to giving meaning to the 94 will, in this case, in 2 ways: by revival and by incorporation by reference. So an A++ answer would have both of those. You see the revival described in your sample here that we're just talking about, but you also see the incorporation by reference described by the sample student answer, and you can see omitting one or the other is not fatal to your answer, but they are both useful in bringing back the terms of a will. Okay, so let's look on the second part of the question, and I think what the answer is designed to do is to show you this one really has 2 major parts to it. Talking about the validity of the testamentary instruments, we're working all the way through that formation and revocation issues, and then secondly, the distribution. Once you've decided which is the valid instrument, how does it all go? And that's what the right-hand column rather, is all about. It says it will be distributed under the 94 will, and again, you see it goes through each of the gifts. The gift to Sam is a lapse problem. You guys will know this already. I don't have to go through it. The person who dies is not a relative, therefore it's easy to rule out lapse in the gift of the $10,000. The gift of the house is an redemption by extinction problem. Again, it goes through the idea that the intent was to provide a house for Fiona, therefore under redemption by extinction, the fact that it's the same neighborhood probably builds on the intent to provide for her, and that's nicely done. And then finally, the residuary to the church, just marching through each of the gifts. And this is where the examiners will check it off. Did you talk about the money? Did you talk about the real estate? Did you talk about the residue? You just want to make sure you've covered it. You want to make sure you've covered each of those provisions in the answer. So I think you have several approaches to the question, and all of them do follow this idea of marching through these few elements. And hopefully with 2 sample answers as well as the approach, this will be something you can easily handle. I'm going to switch over now for a few minutes and talk about trusts, because we want to get through the substance of it, and then we'll go ahead and do the question. So in the interest of your sanity, I might give you a break before we finish the trust outline, just so you can take a bit of a break, and we'll finish it up and then go through the question, because I know how hard it is to sit for this. I really do. I remember this, and it's hard, but in the end, it's something you'll remember. Let's just say that for a long time, hopefully in a positive way. Okay, how's everyone okay? Do you want to stretch and kind of? All right, all right. We'll march on. In trust, like in wills, I have my own roadmap. It may be slightly different than what you have in your approach book, but it does in many ways mimic it. And just like a wills question, a trust question is going to be easy to spot. You'll know that mostly it'll say a trust, but sometimes it doesn't. We'll talk about that. But you want to look at a few separate elements, and here there are 4 of them listed. And I might teach them in my own class slightly out of order in this way, but this is absolutely fine. So you're going to look at creation, which looks at the trusts roadmap. So creation, just like you look at will formation, you're going to look at trust creation. We're going to study the elements of a valid trust. Then you're going to do what I call next types of trusts, because there are many types of trusts that you could identify, and truthfully, once you identify the type of trust, then the rights and the duties of the parties falls into place. And I'm going to give you a little follow-up on that in a minute. Then you go to trustees' duties, which is what 3 is. So I call this in my class administration, trust administration, which includes the trustees' duties. And then finally, you get to modification and termination of trusts. This is a very short topic. All right, again, just to kind of shorthand it and maybe give you a little bit more of a condensed pattern, there are 11 types of trusts. And I know that sounds like a lot, but really there's just one or two sentences that you'd have to say on the bar about each of them. So I'm just going to give you my list, and they're all described in the material. But again, you know, just from the beginning, if you see your list, you could say, oh, that's a so-and-so. So you see the first three there, the spendthrift, the discretionary, and the support. So if you don't mind just taking a few more notes, if you want to number it from 4 to 11 after that, just to have it there, just to look at as your roadmap, then you'll have it there. All right, so I'm just going to march through them. So number 4, charitable trusts. Trusts for charitable purposes, charitable trusts. Number 5 is honorary trusts. Honorary trusts, which are trusts that have no human beneficiaries. Honorary trusts, no human beneficiaries. Number 6 and 7 aren't really trusts at all, but we talk about them in this area. The number 6 is called a resulting trust. A resulting trust, which is transfer of property when a trust fails. Transfer of property when a trust fails. Number 7, constructive trusts. We talked about those. Judicial remedy to avoid unjust enrichment, but they're called constructive trusts. Number 8 is called a secret trust. A secret trust. Number 9 is called a semi-secret trust. Semi-secret for number 9. Number 10 is called a pour-over trust. Pour-over trust. And then finally, number 11 is a revocable trust. So again, you've just got your example there, and once you can identify it, and half the battle is just identifying the type of the trust, and then when the examiner sees you've identified it, that goes a long way. So let's take a quick look at our approach here. And you can see that some of them are listed on page 2, the charitable, the honorary, resulting, and so on. So I haven't really gone out of school by putting them all in one place. Okay, so let's look first at this idea of creation. You know, just like in wills, there are certain elements that are associated with the creation of a valid trust. And I actually have 5 elements, and they're all in here, and again, it's just a slightly different order than what you see. But I have, if you look at the under bar hint, where it says if they give you a trust, then you just want to discuss the following elements. I think that's right. And I would just suggest to you there are 5 elements to a valid trust that you'd want to discuss. Element number 1, intent. Just like with the will, you have to have intent to create a trust. I'll go through them, then we'll go back and explain them. Number 2, you have to have trust property. Trust property, sometimes called the res, R-E-S, or the corpus, C-O-R-P-U-S. You have to have a trustee. Number 3, a trustee. Number 4, you have to have ascertainable beneficiaries, people that can enjoy the trust, ascertainable beneficiaries. And number 5, you have to have a valid trust purpose, a valid trust purpose. You can't have a trust for illegal purposes. For example, I used to say the Charlie Sheen trust for women or something like that, or whatever. Okay, just it has to be for a legal and valid purpose. Okay. So intent. And this is where this comes up on the bar, and actually this comes up in the question here. You want to see that the testator, if it's a testamentary trust, or the settlor, if it's an inter vivos or lifetime trust, has expressed an intent to have a trust. Now what does that mean? Well, the basic thing about a trust is that it divides the ownership of property between the management of the property and the enjoyment of the property. Put another way, there is legal title to property that is enjoyed by the trustee, who can sell property and give property in some cases, and invest property. So that's the legal title. And then there's the equitable title, which is in the beneficiaries. So where the trustees has responsibilities for the trust, the beneficiaries get enjoyment of the trust. So the whole goal of a trust is to split the beneficial and the management components of property ownership between 2 entities, the trustee and the beneficiary. So you want to see that the settlor, that's the person who places property in trust, has an intent to do that. And how this comes up about it. When you say, I hope that this will happen, or I wish this will happen, or it's my desire, That's known as precatory language, and you see that in your outline. Precatory or wishful thinking, but doesn't usually give rise to a trust. So it has to be a specific intent to create a trust rather than just wishful thinking. So that's the precatory language that you see on page 3. Okay, moving on to page 4, again, you see the other elements that we talked about. The race, it has to be an existing interest in property, although it can be a future interest, which is a presently protected interest in property. You have to have a trustee. That's the person who has the title to the property and the responsibility to manage the property. You have to have ascertainable beneficiaries. It can be future children, as long as they can be ascertained at some point within the life cycle of the trust. This is when you sometimes get into the rule against perpetuities. Very unlikely that the examiners are going to ask you about that, but that's what it means to have ascertainable beneficiaries. And then you see the valid trust purpose. The next section on page 4 and 5 talks about the ways that trust can be created. And basically you see 3 ways described on page 4 and 5. You see the inter vivos declaration, the inter vivos transfer, and then finally, number 3, the testamentary transfer. So, put another way, someone who's living, a settlor, can create a trust by declaring him or herself trustee. I hereby declare myself trustee of this clock. That's fine. I don't have to transfer it. I can just declare myself trustee. But if I wanted to declare one of you as trustee for the clock, I would have to make a second type of transfer called a transfer in trust during inter vivos transfer. And then number 3, testamentary. This means if the trust is in a will, that it has to be by transfer. The executor would transfer the assets over to the trustee. Here, starting after testamentary transfers, you see coming up some of these types of trusts that we talked about. Part A, B, and C mention 3 of those: the secret trust, the semi-secret trust, and the pour-over. In the interest of time, we won't talk about secret or semi-secret because they're nicely described there. The pour-over, which is indicated to be heavily tested, only because it's a very common current technique for estate planning, is to create pour-over trust. And all that means is that a will would indicate, so a pour-over trust by definition has a will. There's going to be some will associated with it. And the will is going to indicate that the beneficiary is a trust. So the idea is that the assets from the estate are going to go from the will and pour over, literally, into a trust. Either a trust that was set up before the will was drafted or one that's set up contemporaneously at the same time that the will is drafted. That's an example of a pour-over, so pouring assets from a will into a trust. Okay, I'll just use them. The next kind of trust on page 7 that you're going to see is a spendthrift trust. And let's talk just a minute about those, because they do come up. Spendthrifts are trusts in which the ability to transfer the beneficial interest, that is the property that the beneficiary would gain, is restricted. And to be a valid spendthrift, as it says at the beginning, it restricts both the voluntary and involuntary transfer, or sometimes known as alienation, of the property. So that if you a lot of times you'll see that the father sets up a trust for son. Son hasn't been the wisest investor, maybe has been in jail or hasn't paid his bills. So father creates a trust that says that creditors cannot reach the interest income of son, nor can son alienate or transfer or anticipate, that's a word you sometimes see, his interest in the trust. And the examiners would be asking you to do is to identify this as a spendthrift trust, so that when son takes out a loan and fails to pay back the loan and Bank of America tries to attach the interest in the trust, you can say, as a spendthrift trust, the creditor cannot reach the assets of the trust. That's what the examiners are wanting you to do. But as you can see, there are certain exceptions to this idea that creditors can't reach the spendthrift. And I just want to draw your attention to number 2, the second exception here. The spendthrift restraints are ineffective against claims for alimony, dependence, or necessities or necessaries. So again, it's just knowing the exceptions to the spendthrift rule, being able to say, well, the doctor who provided medical services to son should be able to reach the assets in the spendthrift because that was a necessary commodity that the doctor provided. Discretionary trusts come up in our problem tonight. It just gives the trustee the discretion to pay income or principal or both from the trust. All right. The next issue, the trustee. And this is where Sherry and I were talking about this, and most of the trust questions in the past 5 years have had this element, this trustee's duties element. And kind of unfortunately, like so many areas, this is just a list that requires some memorization. You learn that the trustee has certain duties, and within each of those duties there are sub-duties, and you have to just be able to know them. I'll say from, again, reviewing sample answers in this area, really what the examiners want you to do is they want you to identify the breach. They want you to be able to say, this is a breach of the duty of, and again, X. There's a number of duties. But I find that, the answers that do best are just the ones that can identify the conduct as being a breach of one of these myriad duties. So we'll spend a little bit of time talking about the duties because then you can identify the breaches as you come along. All right. Well, the first thing you see is about the trustee's power. And the power is whatever is in the trust instrument, but also there might be some implied powers. So if you see a trustee selling property and the trust doesn't say the trustee has the right to sell the property, you might want to highlight that maybe the trustee didn't have the power to sell, and that's a breach of the trustee's duty to conform to the terms of the trust, for example. Or you could describe it as an implied power, as you'll see described here. Again, it's mostly just highlighting that you see it. You see that the action was outside the terms of the trust, and it's a potential breach of the trustee's duties. All right, let's look on page 8 together. Basically, your outline on page 8 and then page 9 divides the trustee's duties into two types of large duties. The duty of care, which largely talks about the property. That is the duty that the trustee has to the property. And then on page 9, you'll see the duty of loyalty. And that largely has to do with the duty to the beneficiaries. So the trustee owes duty to both the property, that is to manage the property well, and owes duties to the beneficiaries to be fair to the beneficiaries. So those are two larger duties, duty of care, duty of loyalty, and again, within each of those, let's break it down. Okay, let's look first at the duty of care. These are duties with respect to the property itself. And it says, just look at this statement here. The trustee has a duty to handle the trust corpus, that means the property, with the ordinary caution that a reasonably prudent person would in conserving and making productive his or her own property. This is a kind of shorthand version of what's known as the prudent investor rule. And you see the prudent investor rule actually at the bottom of page 8, which says that a trustee should invest in the way that a prudent business person would invest. And then the statement earlier is kind of an expansion of the prudent investor rule, but just mentioning the prudent investor rule and seeing that you know it would be a positive thing, that you understand that in California, trustees are held to the prudent investor rule, as a prudent investor would handle his or her own property. And just take a look. There's two specific duties of care that are highlighted. I just want to, again, point them out because identifying the breach is half the battle. A, duty to segregate and earmark trust property or trust corpus. And this comes up not too infrequently, where the trustee will deposit trust property into his or her own personal bank account. Or I think last summer the trustee put it in his safe deposit box, which you'd say, well, that's separate because they're not earning interest together. No, it's not separate. If there's any commingling at all of personal property with trust property, that is a breach of the duty to segregate, or sometimes called the duty not to commingle property. So that would be one, identify that as a breach. Second is this duty to earmark, means labeling property. So if it can't, it has to be able to be traced easily as trust property. So look for whether the trustee labeled or identified, or as they call it, earmarked the trust property. Okay, B has more to do with investment strategies. The duty to make productive the trust corpus. And again, there's a series of duties under this that are generally subsumed under this prudent investor rule. But let me give you some examples. This was many years ago, but it could come up again, where the trustee bought so-called wildcat oil stock. And what the examiners wanted you to see was this was speculating, that wildcat, I don't know what, that was an example from the early 90s. You know, today they might say, bought stock in a high-tech company that went bust in 2000. I'm trying to think of something that would be obvious, that would be risky. Here's another one, bought junk bonds. Okay, now just, you guys aren't expected to be CPAs or financial advisors. You're not expected to know the market. So it would have to be something that really jumped out at you as, gee, you know, this doesn't seem like a good investment. So if you see something that really seems off, that's a breach of the duty not to speculate. So that's one of the prudent investor duties, duty not to speculate in these investments that can be high risk. Another one is the duty to diversify. This came up about 4 years ago, where the trustee just bought a single asset, bought a piece of real estate. So that would be a breach of the duty to diversify. The portfolio has to have different risk factors associated with different assets. So if you see a trustee just buying one asset, that's a breach of the duty to diversify. So those are the two that come up most often. Duty not to speculate and the duty to diversify. The duty to buy productive property is, again, also something that comes up. An example would be real estate, just buying real estate that has no rental return, that's just sits there for possible appreciation. So you want to keep the property productive. So look for things that just seem out of the ordinary. And even if you can't remember what it's called, at least you can say it's a breach of the duty to act as a prudent investor. Because a prudent investor wouldn't invest in again, whatever the asset is. And that's how you're going to handle that question. Okay, the duty of loyalty looks more to how you treat the beneficiaries. And here's what it says on page 9. The trustee is a fiduciary, is in a fiduciary relationship to the beneficiaries. This is a strict relationship. The trustee must administer the trust solely in the best interest of the beneficiaries. The way this can also come up is if you have lifetime beneficiaries and future beneficiaries. So you have a life estate to someone and then a remainder interest to another. And let's say that you have the ability to invade the corpus, that is to pay out some of the corpus, and the trustee sells all of the property and distributes it to the life beneficiaries. Well, that's a breach of the duty of loyalty by favoring the life beneficiaries over the remaindermen. That would clearly be a breach of the duty of loyalty, and that actually happens in this problem tonight, completely disregarding one or more of the beneficiaries. Things like that don't treat the beneficiaries fairly. Within the duty of loyalty, it really can divide it up into, again, two separate duties. And I'm deviating a little bit from the outline because this is the way I teach it and I think about it. Within the duty of loyalty, there's really two categories. One is mentioned, one I'm going to add. The first one is duty to avoid self-dealing. That's a big one. Again, easy to spot. That happens if the trustee is buying or selling trust property. And it tells you there, under the duty to avoid self-dealing, as that small number 1, purchase property from or sell to the trust. That is a breach of the duty of self-dealing. Then you see the other ones, loaning money or borrowing money from the trust or taking excess compensation. If you want to spot the breach, if you see the trustee buying or selling trust property, borrowing trust property, you spot the breach. That's a breach of the duty of loyalty. It is a self-dealing transaction. And then the accompanying doctrine to self-dealing is called the no further inquiry rule. The no further inquiry rule. So if a trustee engages in self-dealing, the court will make no further inquiry into the fairness of the transaction. So the trustee says, well, yeah, I bought the trust property, but I paid 2 times the fair market value. So what? Still a breach. The fairness, the good faith of the trustee is irrelevant. The court makes no further inquiry into fairness and just calls it a breach and imposes a remedy. So the self-dealing is, again, pretty easy to spot, but if you can march through that, this is a self-dealing transaction, the court will apply the no further inquiry rule. trustees pleas about fair market value, excess, irrelevant, it's considered a breach. So that's one duty of loyalty. The second, which I'm going to add, which I would have as my part B, is called conflict of interest. So the two major breaches of the duty of loyalty are self-dealing and conflict of interest. So if the trustee engages in a conflict of interest, and that's basically everything else that seems askew, that seems unfair, that involves some wrongdoing on the part of the trustee. When there's a conflict of interest scenario, the court will inquire into fairness and good faith on the part of the trustee, and will ask the trustee, why did you do this? Why did you only pay the income beneficiaries? Why did you disfavor the remaindermen? Things of that nature, where the trustee can defend him or herself by saying it was in good faith and I felt that it was a fair transaction. So self-dealing, no further inquiry, conflict of interest, good faith and fair dealing are relevant to the inquiry. So that's how you might divide up those sections. And then the next one, see, I do want to cover this, is the remedies, because that's important as well. And then we're almost done with this. If you guys can hang on, is it all right? Can you hang on and we'll finish up the outline, or do you want to take a break now? Okay. I'm sorry for those of you who said break now. I can talk really quickly and we'll just finish up and then we'll do it. All right, we're almost done. We really are. The remedies. The three remedies are there under C on page 9. Surcharge, set aside, and remove the trustee. You see those there. So you can call the trustee on the breach, and you can surcharge, that is, they can be personally liable for the breach, have to pay money as damages. They can have to return the property, that's what the set aside, and you can even remove the trustee for the breach. All right, turning over to page 10. You see, I already covered the self-dealing part, and you see that it is a per se violation of the trustee's duty, and the remedies there, affirming the transaction, or what I call waiving the breach, set aside, which is the surcharge that we saw earlier, and then tracing the profits. Those are all laid out very, very nicely. Removal of the trustee is an option. I've never seen that come up on the bar, but certainly it could. And then just finally, ending for tonight, the last section, we're up to our modification and termination. California's been a leader in this area, actually, where in California we have statutory provision that says that trusts can be modified or terminated if to continue the trust would then not fulfill a material purpose of the trust. So put another way, for those of you who studied this in another way, the common law rule was what's known as the Claflin Doctrine, C-L-A-F-L-I-N, named after a famous New York case. And the Claflin Doctrine said the trust cannot be modified or terminated in any situation because to do so might interrupt the material purpose of the trust. The Claflin Doctrine is actually written out for you in the materials on page 11, where under Part 3, the modify or terminate the trust. So generally speaking, Claflin is very conservative and says that trust cannot be modified or terminated if to do so would disrupt a material purpose of the trust. And it's been applied very strictly, where courts find material purpose in almost every element of a trust. That's the common law rule. California, however, is more liberal in that way and does permit the trust to be modified or terminated if there are changed circumstances, and then turning over to page 12, you see under Part 4, Part 4 is actually just a summary of California law, where the court can change or terminate the trust if the purpose has been achieved or if the purposes can no longer be achieved. That's what Part 4A is. It's telling you what California law is in it. So you just talk about material purpose, change in circumstances. All right, page 12, charitable trusts, just trusts for general charitable purposes. You see there has to be a large group of beneficiaries for charitable purposes such as medical purposes, educational benefits, religious, social needs. Those are all examples that would be charitable in nature. Honorary trusts, usually trusts for animals. You set up a trust for your animal. There's no human beneficiary, but the trustee can be on his or her honor. And animal rights have gotten a lot of play lately, so I don't know, maybe you'll see a trust for Fifi, and you'll just know that's an honorary trust. We've covered constructive trust on page 13. Remember, judicial remedy to avoid unjust enrichment. Again, I know this is so hard in detail-wise, but I just want to make one statement about resulting trust, then we'll take our break. Resulting trust, again, it's not really a trust. It's a way that property is distributed if a trust fails. So let's say T sets up a trust to X as the beneficiary, and X has predeceased and there's no anti-lapse. Anti-lapse, by the way, does apply to trusts in California as well as wills. Well, the trust can't move forward because there's no beneficiaries. The only beneficiary has died, so the trust fails. And that what would happen is known as a resulting trust, meaning that the property would go back to the settlor. If it's an inter vivos trust, it goes back to a living person. If it's a testamentary trust, it goes back to the settlor's estate or to the heirs of the settlor, depending on how the estate was structured. But this purchase money resulting trust was on the bar 3 years ago, and so I feel obligated to say it. It was in a property trust crossover question. It was such a nitpicky thing that it was just, oh, you know, how many rules can we memorize? But it did show up, so I'm just going to mention it. Don't know if it'll come again. I'm not actually going to read the rule, but if you read it, it's about giving someone money to buy real property. So it's giving a gift of money for a second person to buy real property, and there's this purchase money resulting trust presumption that showed up on the bar. So that's why I just want to highlight it and mention it. All right, thank you so much for your attention. I know it's really late, so let's take our 10. We'll come back 6 or so issues. This one, I counted 6 major issues as well, so it's right in the range. And from my reading of the question and the answer, there are some facts, I believe there are some facts omitted from the question. Now, have you guys had a chance to read the answers to this question yet? Okay. So when we review them, I'll show you why I think that. I could be wrong, but I think that there was some facts omitted from at least the question I was given, which has changed the answer just a little bit. And let's look at the first part. Oh. Yes, sure. Oh, you haven't handed these out yet?
Not yet.
Okay, sure. Yeah, why don't we go ahead and do that? But you can still follow along, yes, in the answer book? Okay. So look at the question. It says, oh, you don't have the answer in your answer book. So you do not have page 97. Is 95 through 104 is omitted? So Anne, is there a way to copy this answer and hand it out tonight, or is it too late for that? Okay. Well, it's on page 97. We'll forge ahead. For those who don't have it, I will read it and make it available to you afterwards so you can have it. And Anne is passing out the approach, which we can all have together. So I hope everyone can get as much out of this time as possible. Does everybody have the question? That everybody has. All right, so just take a look. In 1990, here in Wanda, husband and wife, properly executed wills. Again, properly executed, don't need to go into the formation issues. Each stating, all my property goes to my surviving spouse, and if my spouse does not survive me, then to the children of Harry and Fran, his former wife. So these are known as reciprocal wills, sometimes known as mutual wills. And then the problem goes on to say, in 91, at his death, he was survived by the wife and by Abby, Carl, and Dan, all children of Harry and Fran, so the prior children. And one of them predeceases Fran, who goes on to change her will. And then, as you know from the problem, there is a will with a hint of a trust and some misdeeds that follow. But wanted to just to have that set out. For those of you who have the answer on page 97, turn to that. And for those of you who don't, I'll read it. But again, I mean, I know it's really hard to see. But if you looked at this, this is even a little bit more text than you'd normally see. But again, you see the issues spotted and highlighted in the short paragraphs that literally just go through the IRAC formation. So it's the same exact thing over and over again. You're not going to, if you find yourself writing without a break for more than, say, 5 lines, it probably is too much and you're going to want to break it up. But let's go ahead and read what the student answers. So the first thing the student says is execution of the 90 wills, underlining it, and then all the student says is the 1990 wills were properly executed, period. Because, you know, when you see a will, you feel too uncomfortable to not say something about it, and even though the examiners tell you it was validly executed, you want to at least, you know, you're taught, start with the first instrument, discuss the validity of the first instrument, move on, and that's fine. That took exactly 5 seconds to do, and it's fine, just acknowledging that the will was valid. Okay, the next thing, will contracts, is where I think our facts are missing a bit. Because there's nothing in our facts that would really suggest that this is an issue. And we didn't cover this, but I want to take a chance to do it now. I'm sorry to have you skip around a bit. But if you would look with me in the outline or the approach book on page 26 of the wills outline, I saved for this for now because I wanted to show it to you in the context of the problem. Contracts regarding wills do come up fairly often. And in California, they're pretty generously upheld. California has one of the most liberal probate code provisions on contracts relating to wills. So that's why I thought it was important to discuss it in the context of this problem. So a testator can make a will, can enter into a contract to either make a will, to revoke a will, or to die intestate. And the contract can be proven in a variety of ways. But if you see in the middle of page 26, you see really the 3 main ways in which the contract can be proved up. That the will states the material terms of the contract. We don't have that here. All it says is we make a will, we leave it to each other, and if one predeceases, then we leave it to the children of the stepchildren, essentially. Okay, that's not there. B, an express reference in the will to the contract and extrinsic evidence proving its terms. Again, no such reference here. It's not there. C, a writing signed by the decedent evidencing the contract. That's not here as well. If you go on and read the probate code, there's actually more provisions that say that a proponent of the contract can prove it by clear and convincing evidence. So it doesn't even necessarily have to be in writing. But again, none of that is here, but yet the sample answer goes on to describe it. And let me read this to you, and this is why I think there were facts that were omitted from our problem. Here's what the student says. Will contracts. The issue is whether Harry and Wanda's 1990 oral promises to not revoke their wills are valid and binding. I think that the problem probably omitted something to the effect of, and when they signed the wills, they promised each other that they would not revoke the wills. Because it would be hard for me to see how a student would leap to the idea that there were oral promises not to revoke the will when there's nothing in the problem. And in fact, I won't read over this, but if you go to answer B, there's even more specific references to this exchange of words, the presence of some of the witnesses to these words. So to the extent that you read the answer where it talks about will contracts and you think, I would have never, ever come up with that, you shouldn't have. Because the California Probate Code says specifically that the mere existence of a reciprocal will is not the basis for a will contract. In fact, you should have ruled out a will contract based on what the problem says, rather than ruling it in. So don't beat yourself up if you didn't get this, because frankly, I think the problem omitted evidence of the contract. So, you know, sometimes what you read isn't always what is matching up with the answer. So I'm going to skip over the rest of that, because it doesn't appear as part of our problem. Okay, let's move on though to part B, reciprocal wills. Does this conclusion, the conclusion that the contract would be valid, change because these wills were identical and reciprocal? And here's where you get more into the facts that we are given. The general rule that this fact of reciprocal wills alone does not raise a presumption of contractual revocability. You could have said that in a little more straightforward answer, but that's all right. However, the event will allow evidence to be presented regarding whether or not there was a contract not to revoke. Because Sis and Buddy were both present when the promises were made, again, that's not a fact that we have in our problem, their testimony will likely prove revocability based on an oral contract. So the student goes on to conclude that there was a contract not to revoke. Now, frankly, this changes the entirety of the answer. because if you read the problem the way we read it, we wouldn't find any contract to not revoke. And so we would say that the will number 1, the 1990 will, was revoked by the 95 will, and that there wouldn't be anything that would change that outcome. So again, your answer is going to vary slightly. It's actually going to vary dramatically from the sample answer because of the omitted facts. So I'm just pointing that out to you when you read it and you think, how could I possibly have known this? You shouldn't have. And your answer is going to be different. But the substance isn't as important as the format. We can still learn from this by looking at the format. But just know that the merits of the claims are going to be different based on those facts. Okay. So let's skip over then to go to the next issue, which is on page 98, the lapse and anti-lapse. In this case, you had in the will, it names the children, not specifically, but as a class, and then after the class gift, there is a death of one of the children who leaves issue. So then, of course, the question of lapse comes into play. And here's how the student discusses it. You see lapse, anti-lapse underlined. The issue is, who are the recipients under the original will 1990? Again, in your answer, you probably didn't analyze that. You probably analyzed the terms of the 95 or the later will. You just have to adjust how you came out on that according to the format that you see before you hear. Under common law, and this is eye-racking, stating the issue, now we're going to the rule. Under common law, the death of a will beneficiary caused the gift to lapse, i.e. disappear. That's fine. However, California has an anti-lapse statute, that's true, that provides that if the beneficiary is related to the testator and his issue, the gift passes to the issue rather than lapsing. Is that right? Is that a correct statement of the rule? No, it's absolutely incorrect. But guess what? This is a model answer. And again, I point this out to show you, they're not looking for perfection. They're looking for a good format with roughly what the rules are. If this were on my exam, I would write the student is weak on the law, because this is not an accurate statement of the law. It's a confusing and in fact bordering on inaccurate, if not wrong, statement of the law. But I like to point out these places in the exam because this is the model, the sample, the perfect answer, at least according to the bar examiners for this administration, and it's wrong. So ballparking it, knowing roughly the language generally can be important or as important as knowing the specifics, because obviously this was quite acceptable for this particular answer. Okay, moving on. Here, because Abby died, her sons will argue they should take under anti-lapse. So Abby was the child of the predeceased spouse, even though they weren't related by blood. Under anti-lapse here, because it's related to the surviving or predeceased spouse, it would be eligible for application. Carl and Dan, however, will argue the anti-lapse statute is there to approximate the testator's intent, and since by the time W wrote her second will, A was dead, W knew that since A was visiting and died, her intent was that C only take under the will. Again, no, that's not really right. Anti-lapse is not a statute about presumed intent. It's really a very precise statute that measures when the death occurred and whether the person is eligible as a related member. It really has very little to do with intent. So again, this isn't a correct statement of the law. Sample answer. Need I say more? And the student goes on to do that. All right. Now let's get to the trust part, which is where we're studying what we're studying tonight, which is at the bottom. So the student kind of works through the will and the anti-lapse issue and then gets to the trust. Okay. Valid trust, underline. We know where we're going with this issue. We're going to formation and creation issues. Is the trust within the 1995 will valid? That's the issue. The rule is that a trust created by a will must contain all the elements of an independent trust. So that's, again, the rule. Here, comma. Now we're getting to the application. Simple IRAC, step by step, nothing fancy. W clearly intends to create a trust. The language is clear. What language? Wouldn't it have been nice if the student says that it says as trustee, as an example of an intent to create a trust. However, moreover, it has a valid purpose, the support of the beneficiaries, trustees are appointed, and so on, ascertainable beneficiaries. This could have been done a little more elegantly, where the student said, here are the elements of the trust, intent, beneficiaries, race, purpose trustee and explained how each of the facts matched with the elements, that would have been a little more elegant, but this was fine. It was all contained there. The elements were there. Moving on. The wording regarding the beneficiaries is somewhat ambiguous in that the beneficiaries appear to be only the children themselves, and the trust ends when the last dies. This would seem to give a resulting trust to W heirs. No, that's not a resulting trust. A resulting trust is a trust that fails. The fact that a trust is over when a life interest is distributed isn't a resulting trust. It's just the remainder interest in the trust vesting in the remainderment. So again, this is an incorrect statement of the law. This is not a resulting trust. It has nothing to do with the resulting trust. Sample answer. Okay, you see the theme here. Lapse. By the way, lapse does apply to trusts. So if trust beneficiaries predecease, the anti-lapse statutes, the same rules will apply. All right, let's go on to duties. Again, this is heavily testing the duties of the trustee. Duties of a trustee underlined. What were Sis and Buddy's obligations as trustees? That's the issue. The student frames the issue here in the form of a question. I don't see that very often, but obviously that was quite acceptable. Trustees are in a judiciary relationship with a beneficiary. No, that's fiduciary. They are not judges. Students getting very tired, really making some mistakes here. The trustees are in a fiduciary relationship with the beneficiaries. They must act in good faith for the benefit of the beneficiary. Even the totally discretionary language does not relieve them of the duty. Good faith is implied. That's fine. Okay. Now, you could have had another subheading with something like duties to the property, duty of care to the property. It's fine you don't, but you could have in that case. Trustees must monitor the trust property here. S distributed all the revenue to A sons who would not be taking under the trust. This is a breach of the duty. Again, not really. We don't need to go into too much of it, but that's not really what the breach was here. But it's described in this way, and it seems perfectly fine. Trustees must account to the beneficiaries, which they failed to do, meaning they have to give them a statement on a periodic basis, giving them information about the assets in the trust. That's correct, and they didn't do that here. S&B would argue that the young boys without a mother needed the property now, but since they are not trust beneficiaries, this argument will not prevail. Again, extrapolating a little bit from the facts, this is safe. This is a valid point to bring in, and the student does a nice job of looking beyond the facts to make that point. Finally, a trustee may not delegate his duties under the trust. This is actually the main breach here, is the duty not to delegate the responsibility. And this was a good thing that the student picked up. Again, it would have been nice to have a point heading that said duty not to delegate or something of that nature. Here, B allowed S to do all the work, make all the disbursements, handle everything. A co-trustee may not get by simply acquiescing to his co-trustee's judgment. That's correct. Because S is dead, B will be held personally liable. And that's another thing to add. When a trustee breaches the duty, typically the remedy is personal liability on a part of the trustee. And that's important that the student put that in there. Mostly giving $1 million to non-beneficiaries, probably can't get indemnity from the trust because he doesn't have a good faith claim. And I'm not sure what that means, but that was fine. And then you see a conclusion here where the student concludes. All right. I just want to show you, if you look over, for those of you who have it, there's another answer here that's very different, actually, than the first answer and raises, in many ways, completely different issues. So I just wanted to point that out to you. So we'll take a few minutes to go over it, then we'll look at the approach, and then we'll wrap up. This is page 101 in the answer book. The first issue is the wills, the first wills, and they talk about those, and they talk about the wills being valid. And then the second part, the promise not to revoke, again, not part of our fact pattern, but it clearly was part of the original question. We won't go over that. But look on page 101, estoppel. So the student thought this was a crossover remedies question. And maybe it was. I don't think it was designed to be a crossover remedies, but the student talks about estoppel and later on about latches, which are really remedies issues. But obviously the examiners thought it was fine. And because they did such a good job of discussing those issues, thought it was an excellent answer. If you look on page 102, keep going on, you see the latches argument being made with much less discussion about the merits of the trust. But just to go over the trust issues, finally on page 103, you see the top pour-over trust. Does everyone see that has it? W's 1995 will creates a pour-over trust. No, it doesn't. This is not a pour-over trust. This is a testamentary trust. There's some confusion here, but again, all is forgiven. But that's actually not right. It goes on to talk about pour-overs. You see some wills doctrine in here with the incorporation by reference and acts of independent significance, trying to validate the trust. And then finally at the bottom on page 103, you see the trustee's duties. And they're fairly similar to what you saw earlier. They're just designed a little bit differently. But again, it's noting the breach, highlighting the breach, and discussing it. Finally for tonight, let's take a look at the approach, which Anne, you handed out. Okay. And this isn't filled out quite as completely as the other is, and I think it's just to give you a chance to do that. So let's just quickly look at this and how we might have set it up. Again, the approach is designed to take into account the call of the question. And you see that on both sides of the columns here. So on the left-hand column, the question is, should the court terminate the trust created by the 95 will because of the promise not to revoke her will? And then you go through the wills part of it, the contract relating to a will not to revoke, the mutual wills, and so on. And then on the right-hand column, you have the second question is, should the court require Buddy to repay the $1 million? In other words, getting to the merits of the trustee's duties. And again, highlighted there, you see the trustee's duties, the duty to administer, not to pay non-beneficiaries, the duty to co-trustees, meaning the duty not to delegate. You see that later on, the duty not to delegate. The duty of impartiality. This is where you don't just pay one of several beneficiaries for not a valid reason. And then the remedies for the breaches later on. And again, it's a good way to divide it up. The validity of the trust, the type of trust that it might be, and any breaches of the fiduciary duties, including that list along the way. So I think that's all I have to say. And I realize it's a little early. Does that upset you to end early? Oh, all right. But Anne, you have things to hand out? Yeah. And I'm here. Okay, and I'll stay as long as you need or you want to.